You might pick a different trustee for incapacity than you would pick for after death. That's a point that needs to be taken into account.
Yeah, you might pick the person that's actually physically taking care of you to be the trustee if you're incapacitated.
Exactly. Which may not be the person that you think would be the best choice for after you die, settling your estate. So just generally, when we're picking a trustee, what are we looking for?
It should be somebody who's trustworthy, who's going to do the job and the legal requirements to do the job correctly.
And they don't have to know anything about the law. The trustee can hire an attorney to help them. And honestly, we suggest they do.
Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello, and welcome to Absolute Trust Talk. This is our live on Facebook and various other platforms streaming podcast at Absolute Trust Counsel. And I'm here today with my associate attorney, Madison Gunn. I'm Kirsten Howe, by the way. I guess I forgot to say that. Most of our audience probably recognizes my voice at this point. And this is the Thursday right before the big 4th of July weekend. So, we're all very excited. We get to have a 3-day weekend. Madison, what are you getting up to on this weekend?
We are going quasi camping. We have a travel trailer, so we're taking that out for the weekend. But we're coming home Sunday night because in our town on Monday, it's like festivities all day for 4th of July and our trailer storage is like downtown. So we're going to come home before we can't come home and then drug the dogs. So the fireworks don't.
Yeah, that's it. That is a challenge. I don't have dogs, I have cats, and they hear the fireworks because, that's in the 3 weeks leading up to 4th of July, we have a lot of that happening, but I haven't noticed them really being too freaked out. So hopefully that will continue.
That's good. Yeah, we only have one who's a wreck when that happens, and it has to be particularly big, but that'll be really bad this weekend. So
sure. Yeah. All right. Okay. Well, on with the show. Today, we're going to be talking about who should be the successor trustee of a trust. And this is a question we get in one form or another pretty often when we are helping clients planning their estate plan. It's a very important question, of course, and getting it right can really have a big impact on, on future family relationships. And we've seen this. We've helped a lot of families set up estate plans. We've also helped a lot of families administer an estate plan after death. And we've seen all kinds of trusts and families and how they work or don't work. So we just want to share our experiences with our audience. And what we're going to do today is go through the basic options and discuss the pluses and minuses of each. There's no right answer. Every family is different. Our clients have to decide what will work best for their families. But our job is just to make sure they've considered all the possibilities, they've made their decision carefully. So just to make sure everyone is on the same page, knows what we're talking about. What are we talking about? When we say successor trustee, what are we talking about?
Yeah. So in your normal, revocable, or living trust, so that's what the majority of our clients have. There might be some fancier trusts, but for this one, we're just talking about your regular old revocable living trust. That is the foundation of your estate plan. When you set that up, you are the trustee. You're also the grantor, the settler, meaning you're the one that puts the assets into the trust, but you're the trustee. You control everything. You don't concede control to anybody else when you set up a trust. But if you become incapacitated or disabled, or you pass away, you've already named someone in your trust document to take over for you. And that is the successor trustee. So in our case, it's the trust administration. That's usually where this comes into play after somebody has passed away.
Right. And the trust document lays out what the successor trustee is supposed to do. So that's between the document and the probate code and the California case law. The trustee's job is laid out, but what we are talking about here, we're focused on who should be that trustee that will take over if you become incapacitated or die. And that's an important point too, is that it could be either one of those situations. And you might pick a different trustee for incapacity than you would pick for after death, that's a point that needs to be taken into account.
Yeah. You might pick the person that's actually physically taking care of you to be the trustee if
Sure.
you're incapacitated.
Exactly. Yeah. Which may not be the person that you think would be the best choice for after you die, settling your estate. So just generally, when we're picking a trustee, what are we looking for?
Well, this is a little bit of an obvious answer, but I think it doesn't go without saying necessarily. It does go without saying, but a lot of people don't necessarily think about that because their questions are, well, what if I don't trust them? And I'm like, well, don't pick them.
Right.
So, I mean, you really do have to trust the person. I know most people think, well, it's after I die, who cares? But it should be somebody who's trustworthy, who's going to do the job and the legal requirements to do the job correctly.
Mm-hmm. And they don't have to know anything about the law. The trustee can hire an attorney to help them. And honestly, we suggest they do. So they have to be trustworthy, hence the name trustee. I think another important point is they have to be someone who will reliably do the work, who has that kind of follow through personality. Like you can take a job and procrastinate and just dilly-dally and not get it done, but that's not going to sit well with the other beneficiaries.
Yeah. And I think sometimes if you pick someone who is going to do that, that's their personality. I mean, it's not like it's a surprise that would be something that they would do. Usually, someone's personality is you're setting them up for failure to breach their fiduciary duty to those beneficiaries. So if they just go AWOL and are no longer completing the trust administration and they're sitting on all this money and haven't distributed it or done what they're supposed to do, that opens them up to a lawsuit. And like for us, that's our job, is to prevent that.
Right. And we do what we can, but we cannot force our clients to sit down in the chair and get their work done.
Right.
We can barrage them with phone calls and emails. And when is this going to happen? But you've got to start with picking somebody who understands they got to get the job done.
Yeah. And then another one is just availability or bandwidth. Are they, do they work 80 hours a week? They're probably not the best person necessarily to do that. And as much as, like we said, we can do a lot for our clients, and most trusts allow those trustees to delegate out a lot of the tasks. I mean, they're not preparing the tax returns. They're not the ones, they don't even have to be the ones that clean out the house. They can hire people for everything, but we can't replace them when it comes to needing their signature at the bank, or going to the bank to do things, or coming into our office to sign documents and things like that. So there are some things that we just cannot have them delegate out. So they have to be available.
Yeah. And it is important to, I think, point out to people who have never served as a trustee, when someone dies, well, just focus on that. It can be quite a bit of work, and in fits and spurts. There are periods of time where the trustee is working pretty diligently, pretty heavily, steadily. It's almost like having a little part-time job. So, you pick a child, for example, who has children of their own, and they're trying to get to soccer practice and juggle a career and all the things. They might not have the time.
Yeah. We have plenty of clients who take time off of work for weeks or months just to get this done.
Right.
So,
yeah. So that is a consideration. Also, geography could enter into it. If you have a choice between a trustee who's in town and a trustee who, lives in New York, maybe just think about it. It's not the be all and end all, but
no. But if it's your incapacity trustee, that might be more difficult.
Yeah, exactly. That's why, it's important to think of those two things kind of separately. Incapacity and death, it might be two different people.
I mean, the whole thing is logistics. And the whole thing of trust administration is you have your people telling you, the trust document tells you exactly what to do. You just have to execute the logistics. So if being 3,000 miles away is not a good idea, then it, or it doesn't logistically help, it just hinders it. That might be something to at least address with the person you're naming.
Yeah, good idea. Okay, so those are kind of the basic considerations to keep in mind when you're trying to identify a successor trustee. There are a number of different types of people who could serve as successor trustees. And the first one we'll talk about is the probably most common one. For most people tend to gravitate toward naming a child or children, their own child. So if you're thinking about naming a child and assuming you've already determined they're trustworthy, reliable, they have the availability, that kind of thing, then we have to get, I think, into should we name just one child or multiple children? So Madison, what do you think about that?
I think there's pros and cons. Obviously, everything very, as Kirsten and I would say, it depends. It very heavily specifies on your children and your family dynamic, you know, and be realistic because, everybody gets along. Does everybody get along under extreme stress? Is everyone getting along after you die? Are you what's holding it together? Because that's, it has to be realistic. There are pluses to it. I mean, if you have 2 kids and that's it, and they're the only beneficiaries of your trust and they're the co-trustees, guess what? They have a lot less work to do because they're both responsible for knowing everything. They don't have to produce an accounting. They don't have to send out that notice to the beneficiaries because they are the beneficiaries.
Mm-hmm.
So, it's cost effective, but you have to assume they're going to get along. They're going to agree with everything.
Yeah.
They're going to decide how they want to handle everything. There's other considerations that are very specific to maybe what your assets are. If you have multiple homes or a house and one wants the house and one doesn't, those are all points that they could, go after each other about. And so as Kirsten and I would say, if you communicate with your kids, that can solve a lot of problems on the back end.
And communication is always, the communication is the elixir of life.
Yeah.
It makes everything better.
Yeah.
Or at least not terrible.
Yeah. So proactive is better than reactive.
Yeah. And I mean, clients very often think, they'll say this right to us, our kids get along just great. And maybe they do. But I don't know how you can know that. How can you know that? Because you don't
be on their
know
best
what
behavior
happens
around you.
Yeah. You don't know what happens when you're not around. So I would say, don't make the assumption that your kids will get along. Yeah, it can be more efficient for all of the children to be co-trustees if they're all the sole beneficiaries. Yeah, it can be faster, quicker, cheaper, but maybe they don't agree on things and they're going to get, a decision has to be made and they'll get locked into some kind of impasse and they can't move forward.
Yeah. Or they're across the country from each other and they both have to come here to sign something, or they both have to sign and notarize all their documents. It could take twice as long.
Yeah. When you have multiple trustees, they all have to participate in all the activities. They've got to all make the decisions together. And if there's a decision that they can't agree upon, it just logistically can get a little more complicated. And also it can lead to an impasse among trustees, and impasses get resolved by going to court, which is the exact opposite of what we're trying to do. By setting up a trust, we're trying to keep your family out of court. So, it works both ways. It can be a plus. It can be more efficient. It can also be less efficient. And it depends on the family. If you name only one, it is a lot of work. And the other children might not appreciate how much work it is. And that can result in impatience. We've seen that. We've seen where the other beneficiaries are saying, where's my money? 2 months after the death, where's my money? Well, we're not anywhere near being done with all the trustee work, and they have no understanding of that. And so the trustee child gets that heat, and that's not pleasant.
Yeah. And of course, the big thing is there's usually resentment on both sides. So you have the one who's been chosen is resentful that they have to do all this work and their siblings just get to sit there and be like, where's my check? And then sometimes the siblings who don't get chosen are resentful because they think they should have been the one chosen. Yeah. Even though I am almost 100% sure that if they were chosen, they would not feel that way.
Yeah, that's one of those, the grass is always greener.
Mm-hmm.
And the one other point to bring up, I think here is trustees are entitled to be compensated for their work. It is work. It takes time away from all the other things they would much rather be doing. And the law says you can be paid for that. And if you have one child doing the work, getting paid, the other children might feel a little resentful about that. They feel like, oh, he's getting a bigger inheritance. It's not a bigger inheritance. They're getting paid for work.
Yeah. It's
but
taxable income.
it's taxable income. So, these are just little aspects of the family dynamic that I think people have to take into account a little more carefully. Okay, so is there anything else we need to say about children as
Yeah, I'm going to point out just one thing, and we don't have to go into it, but if you have money for your children that's going to stay in trust for your child, and you have one sibling as the trustee managing money for another sibling, I guarantee you, no matter how well they get along, they will not later. So I would avoid doing that at all.
Yeah, don't do that. Don't ever have one sibling be the trustee of another sibling's money. That's
like a long-term trust, not just being the trustee of the trust itself where it results in checks handed out. It's like when it's an ongoing, you get $500 a month until you die type thing. Don't have one sibling be the trustee over the other.
Yeah. We see that more commonly in the special needs realm.
Yeah.
That can work a little better depending on the sibling in question, but we always try to create a way for the trustee sibling to step down easily if things get tense. You don't want your death to cause your family to hate each other. That's right. You just don't want that, Yeah,
your death's probably stressful enough. So, it's not, we don't need to add fuel to the fire with the.
Yeah. So sometimes what we do is we recommend, I'd like to, as often as I can squeeze it in there, recommend that clients consider having a third party, an independent person be the trustee for all of the reasons that we just talked about, rather than one of the children having someone independent. So in California, an option for people is what we call a licensed professional fiduciary. And Madison, you want to explain a little bit about what that means?
Yeah. So it's a profession regulated by the state of California. I think it's the Department of Consumer Affairs that handles that, just like they do contractors license or therapists. You have to go through school. You have to do, the required education. They are licensed. So, they have their background check, fingerprint, DOJ, all that fun stuff. They have continuing education they have to complete, just like us. We had to go through all of that too. And in fact, attorneys are also licensed professional fiduciaries. And that's what they do. They're professional trustees, essentially. They get everybody, if it's an ongoing trustee, they get everybody on bill pay, handle all of the bills, take care of all of that. But otherwise, they also can wrap up trust administrations and do that, tie it up with a nice little bow. If everybody hates them, nobody cares because they're not a family member. So it's not, they're a completely neutral third party. And the good thing is a lot of times they'll also do work if you're incapacitated. So that's also an option if you're worried about one child accusing another child or any undue influence because they're now a caregiver, and all of that. So it's a lot easier to, I recommend them all the time.
Yeah.
All the time. We routinely list to people.
Yeah, I agree with you. It's important that clients consider that. And, we get people who will raise objections to it like, oh, no, I can't do that. Here's the most common objection. Well, then you have to pay them, don't you? Yeah, you do have to pay them. But what I say in response to that is, aside from the things that we just mentioned, such as, yes, but isn't that money worth it to keep your family from hating each other? What's also true is that the professionals, they do this all day, every day. That's their job. They're professionals. They know what they're doing. And we have professional fiduciaries as our clients. We represent them in their trust administrations. They are so efficient. They almost never need our help compared to a family member trustee who doesn't know what they're doing. They're always asking, not that we mind. We want them to ask because we want to get it right. But the professionals don't need us to, stand behind them and make sure they're doing everything right. They know what they're doing. So in the long run, you save a lot of money on legal fees.
Yeah. We've talked about this on prior episodes when it comes to, being a good trustee or things not to do as a trustee. And it's always like follow the instructions, because if you end up creating more work and then that's more work for the attorney, that's more billable hours and that takes money right out of the estate and the trust. And, if you have a professional trustee, the fiduciaries that we represent, we have to check in with them and be like, is this case still going on? Because that's how little we hear from them.
Yeah, that's exactly right. Yeah. Is that case over or what?
Yeah. Is this still open?
Exactly.
Can we close this? Yeah.
That is a really good point. So, and they take, as Madison said, they just take the drama out of the whole situation. Okay. So minuses with the professionals.
I mean, I think a big minus is that there aren't a lot of very young fiduciaries, or if there are, people are like, oh, they don't have the experience. So of course, if you want someone with 20 years of experience, they're probably going to be your age or the same age as that younger sibling you might also want to name, and we always tend to suggest at least having one trustee a generation younger than you, because if everyone's becoming incapacitated or dying in the same decade, it's not helpful to have all of them listed as your trustees. But that's the difficulty. However, some fiduciaries are now working it to where you name their company and then they have subsequent fiduciaries within their firm. So, I mean, that's one of the ways that can be worked around.
Yeah, a lot of the professional fiduciaries are solos, but we're seeing kind of more and more they're figuring that out, and they themselves are bringing in younger partners so that, if something happens to them, you still have somebody. And the other thing is what we recommend and do is make sure that the trust has a way for another fiduciary to be appointed if something happens to the one that you pick. And you don't even have to pick one.
Yeah, you can give your children or one child or your sibling or your neighbor or whoever you trust the authority to name a fiduciary at the time that it's needed.
Yeah, when the time comes. Because if you're doing your estate planning, in your 60s, at least one spouse is probably going to be around for 25, 30 more years. If you name a fiduciary who's currently working, they're going to be retired by that time. So we have to build in a mechanism to make sure there's an easy way for the family to get a fiduciary in there. But all of that can be done. I like to tell everybody all the time, because they get bogged down in what happens if I die tomorrow versus what happens if I die at 95? And I'm like, well, we can plan for all those what ifs. Right.
You can put all the what ifs between now and, 2050. You can put it all in there. So, I mean, that's what we're here. That's what we're here for. Yeah. Is to ask you a million questions. As macabre as it might be, we're not trying to kill people off early. We're just trying to, make it so you don't have to update your trust every few years. That's for things that you shouldn't have to update it for.
Yeah, we try to anticipate all the likely things. Okay, so if people want to learn more about licensed professional fiduciaries, they do have their own organization called PFAC, Professional Fiduciaries Association of California. They have a website, pfac-pro.org. But if you just put PFAC into the Google bar, PFAC, you'll get there. And you can read all about who they are, what they do. And you can even find fiduciaries. They have a search function on their website. So I encourage people who are listening to take a look at that. And they're very nice people. They tend to be very nice people in our experience. Anyway.
Yeah, they got to get along with strangers.
Mm-hmm. Yeah. And a lot of different personalities. They have to be able to navigate, because you don't get to pick and choose. You get the beneficiaries that you get. Okay. And then there's one last alternative. We talked about having the children, having the licensed professional, and then finally we have
corporate trustees. So a bank, usually it's a bank, but whatever it might be, Chase Bank or JP Morgan Chase or Fremont Bank, whatever it might be. They usually have a trust department, and, they're not going to go away necessarily. I mean, we have seen some banks go away in our lifetimes, but,
Yeah, that happened to me in a case, maybe before you started working with me, but a bank was named in a very old document, and we couldn't find a trace of that bank.
Yeah. How do you know, when all those mergers and acquisitions were going on in the 80s and 90s, how do you know where it ended up, or got chopped up, and you don't have any way to know where it went? So,
yeah, I'm sure that's what happened. But so
that's where you can throw that mechanism in there to have someone else name an alternate in case the first one's not.
Right. Got to have a mechanism. Even banks sometimes die. So it's very rare, but sometimes it happens.
Yeah.
Okay. But there's pluses and minuses aside from will they last forever?
Yeah. So the pluses are mostly that they'll last forever. Also that they're a neutral third party that can handle everything. They're usually licensed professional fiduciaries within the bank. So that's not a big thing. The minuses are more that, they might require a minimum size for the trust.
Yeah.
So they might say that the trust assets have to be $1 million or more. And then their fees tend to be a little bit higher. They take a percentage of the estate, and then they like to invest it their own way and do all of that.
Right.
They're going to use their own products, of course. So that's a given, I think. I mean, it's not a surprise, but if people don't like that, then that's not what they should choose.
Right. Yeah. You need to, with the corporate trustee, I think you need to investigate what their management/investment policies are. As they're going to sell everything you have and put it all into their proprietary investments. Some corporate trustees do not like real estate, and they're just going to try to get out of that, but they'll sell your real estate. So if that's not what you want, you need to find that out ahead of time.
Yeah.
That's the one type of asset that I've seen. Some of them we don't really want to be landlords,
Yeah. So if you want your family home to be held in trust, or that family cabin to be held for 50 years for everyone to use, a bank may not be the best fiduciary for that.
Yeah. Or there may be a bank that would be good for that, but you just need to do a little bit of homework. Yeah. Okay. So what have we learned from this conversation?
Yeah. So everybody, you need to talk to your children and talk to your family members. If it's not children, we do understand that it could be nieces and nephews or siblings. I don't want to exclude anybody, but yeah, talk to your families, let them know, just as we advise talking to them if you are going to make any type of unequal distributions. So there's no surprises. Nobody likes surprises. So let me just tell you, it looks fun on TV with a surprise party, but anywhere else, no one likes surprises, especially when it comes to some burden you're going to take, or, some inequity between family members. So it's just easier to talk to them and explain the expectations. I mean, we have people that plan meetings with us where they ask us, what are they going to have to do? What is that process going to look like? And then they're like, oh yeah, I don't want to put that on my kids.
Well, yeah. And kind of related to that, the question of talking to your kids, if you're thinking about naming just one, or you're thinking about naming multiple children, I would say, do what you can to kind of talk to each one individually alone and say, come on, what do you really think? How would it really be for you if I named all three of you as co-trustees? What do you think about that? I think just be really honest about it. And
especially that oldest daughter. Because if you're sitting in a group with all your siblings, they're going to just do what they always do and step up, so it's like, ask them to be realistic and be honest about it,
Yeah. We are happy to not name you, to not dump this on you like everything else in the family. Just tell us what you really think. Yeah, that's a good point about the oldest daughter. All right. So let's go to our questions. I see we have a couple here. If the document names two co-trustees, can't one of them just resign to make it easier?
Yeah, that's possible. I mean, most likely that language should be in your trust agreement. So hopefully it says that. But that's an option.
Yeah. Well, and they can always resign.
Yeah.
Even if it doesn't specifically
that's
say
true.
that.
Yeah.
Nobody has to do a job.
No, we can't force that.
We got rid of that with the 13th Amendment.
Yeah. The procedure for how they do that would be in the document.
Is often in the document, but absolutely they can resign. And sometimes that's a good thing.
Yeah.
Okay. How much does a licensed professional fiduciary cost?
Well, it depends. Yeah, it depends. I would say most would provide you with their rate sheet. And I think it depends on the work involved in your trust administration. So it depends. If you die and all you have is, an IRA and a big brokerage account, and that's what you're living off of, and you don't own any real estate, they're probably going to charge an hourly rate to administer everything. Yeah. If they have to sell a couple homes, they're probably going to charge a percentage of your estate, or the percentage of the value of your assets. That's in the trust, not if your IRAs are outside the trust, no one's taking a percentage of that. So you don't have to worry about that.
Yeah. But so the point is they vary.
Yeah.
It varies. A single fiduciary will vary depending on what the case is like. And you just have to ask. They'll tell you. They don't like surprises either.
No.
Nobody likes surprises. Okay. So what if the parents name only one child as the trustee and that child really doesn't do the job correctly? What can be done about that?
Well, it depends on what the trust says and whether that sibling is still, or that child is, if they're in communication with their siblings and they can just talk about it, they can sometimes resign and appoint one of the other siblings or appoint a fiduciary. Worst case scenario, you could sue your sibling for breach of fiduciary duty.
Yeah.
The
beneficiaries can always go to court and complain about their trustee. We really hate to see that happen within a family, but there's always recourse. And usually if that happens, the judge sends the family to mediation to try and work it out. And you can always go right to mediation. You don't have to, you don't have to start a lawsuit.
Yeah.
But yeah, that's what we're trying to avoid.
And if they're not intentionally doing something wrong, that would drain the trust assets too.
Right.
So it's kind of a balance.
Yeah, that's very expensive way to go. So, you want to explore all other options before you go with the nuclear filing a petition against your sibling. Yeah.
Yeah.
Okay. Anything else, Madison, you want to add to this?
No, I think if you have questions, ask your attorney. I mean, that's the big, right? It's just a lot easier to talk about it now than for there to be a meltdown. Heaven forbid if you're incapacitated and you have to also be in the middle of it, but also after you pass away. It's just no need to have extra stress when you can. The whole point of doing this is to avoid stress later.
Yeah. Okay. I see another question, maybe two. Let me just go back to that. I'm sorry. They keep popping up. This question: husband loses capacity before wife established a trust or a power of attorney, no children. What should the wife do?
Oh, so we get these quite a bit, but you're going to have to petition the court for some things.
Depends on what needs to be done, but because it might be a conservatorship, that would be one possibility. If it's just some specific transactions that she needs to take care of, there's an alternative procedure only for married couples where you can petition the court for permission to take care of certain things. So, but it's likely going to involve court.
Yeah.
One way or the other. Depends
on the asset.
Okay. Usually. So the follow-up is she's trying to get a reverse mortgage. So if it's just this is all we need, you want to take a careful look at what are all the things that we need to do. And then you might petition under it's section 3100. Am I saying that right? Yeah.
I think so. Yeah.
For the incapacitated spouse, and the judge can grant the wife the authority to do that particular set of transactions. Even though the spouse is incapacitated. So great question. Thank you.
Yeah.
Okay. All right. Well, Madison, it's a pleasure as always. Thanks for your wise advice. And thank you all for listening and watching. Those of you out there who are watching, you saw that we answered questions live here during our live stream. If you have questions and you weren't watching us live, you can always email them to us at info@absolutetrustcounsel.com, and we might answer them on another show, or we might answer them directly to you. But thanks so much for tuning in, and we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.